All right, let's proceed.
Yeah, thank you, Your Honor. May it please the Court, my name is Michael Kopuk, and I represent the Bridgewater State University Foundation, which is the appellee, not the appellant, but I'm arguing first because you allowed our petition for further appellate review. The foundation is a Chapter 180 corporation, also qualified as a charitable institution under 501c3 of the Internal Revenue Code. It was created pursuant to Chapter 15A of the Massachusetts General Laws, which encourages state educational institutions to form private foundations to assist in fundraising and other means of support. The statute says that these foundations are to exist exclusively for the benefit of the state educational foundation. The institution that we benefit, of course, is Bridgewater State University. The university is a state university, which is itself a tax-exempt entity. Its property is tax-exempt as property of the Commonwealth. Our property is tax-exempt so long as we occupy it and use it for our charitable purposes. We own 6 pieces of property which are part of the campus of Bridgewater State University. 3 of those are vacant land. They're used for recreation of the students. 1 is occupied by the Political Science Department. It's a building. Another building is occupied by the Alumni Department and by the Foundation's own offices.
How did that come about? I mean, I'm just interested, why aren't they owned by the college, by the Bridgewater State itself?
Yeah. Well, if you read the amicus brief, you see the tax justification for this. And this is the reason why the legislature created independent, private, charitable entities to do that. Because there are tax benefits to the donors to give money to to this institution rather than to the college. And the fact is, if you gave real estate to the college, it becomes real estate of the Commonwealth, not of the college, so it's subject to disposition by the Commonwealth, and you lose some control if you're a college or university in that case. And also, you get a larger tax benefit if you donate property to this 501c3 institution rather than to the Commonwealth. So there are reasons that help fundraising and support of these institutions if you have a private entity. And that's why the legislature created these private entities.
Yeah, that's exactly what was the intention.
That's the intention,
to
exactly
encourage
right.
donations, further donations, and to support higher education.
That's right. So in this case, we own these 6 pieces of property, as I said, and the assessors of the town of Bridgewater in 2007 and 2008 assessed taxes against those. We then appealed that to the Appellate Tax Board, which ruled that the properties, in fact, are used for our charitable purposes, which is not in dispute here. The question is whether they are occupied by us. The Appellate Tax Board said, yes, they are. And in fact, the Appellate Tax Board, I think, conflated the concepts of use and occupancy, and I'll discuss that more in a minute. Then, of course, the assessors themselves appealed to the appeals court, and as you know, the appeals court reversed, and they found, as a matter of literal interpretation of the statute, that the properties are occupied by the university, not by the charity. And so they rejected the Appellate Tax Board's conflation of these concepts in that case. And, of course, the result is that the property becomes taxable. Now, I stand by my brief, and I'm not giving up any of those arguments, but I really don't want to talk about the points in my brief. Really, what I want to talk about here today is the logical consequence of upholding this ruling of the appeals court. And the logical consequence of it is really that we could never hold real estate that wasn't tax exempt. Because if you think of all of the ways that the foundation might hold real estate, there's not one that would be tax exempt under the arguments made by the assessors. And let's pose some hypotheticals. The first hypothetical is, let's suppose we simply buy this property and hold it and fence it around and don't use it for any purpose. Well, that's clearly not a tax exempt use. We're not using it for any purpose whatsoever. The other option might be is we, say, lease it to a commercial entity and hope to get the rents. That clearly is not a tax exempt use because it's commercial use. It would perhaps generate not only real estate taxes, but income taxes, unrelated income of some kind. So that doesn't help us. Let's say we lease it to another charity. Well, under the strict interpretation of the statute, that would be a tax-exempt use, but it's inconsistent with our charitable purposes to exclusively benefit the university.
And the universities are not charities in that sense.
Right, because they're owned by the
And
state.
the universities
Right.
are not charities.
It's
in
not
the
a charity,
sense
it's a
of
state institution. I mean, that's the
Yeah.
sort of paradoxical
Gotcha.
thing here.
Yeah.
The other option is, which this appeals court really suggested to some extent on a footnote, is transfer the property to the university itself. And I said, in response to your question, that doesn't work. It becomes
Right.
property of the Commonwealth and goes out of our control, and donors don't like that. They want property to be restricted if they're going to give it to us or give us the money for it. And then the final and fifth option is do what we are doing, and which other foundations have done in the Commonwealth, as you know from the amicus brief.
Or you can build I suppose, build a little shed on the corner of each piece of property and put a desk and a phone in there for use of the foundation.
I suppose we could do that. I'm not sure that would be a very material use of the property for the benefit of the university. We want something that really genuinely benefits the university. And at the present time, the way it's organized, we do genuinely benefit the university. We are holding developed land that's used by the students but is available for future development, and it's contiguous to the university's property, so it protects them to some extent. The offices and buildings are used for fundraising and professors. So this is clearly within our charitable purposes, and it's clearly a charitable use. The question is occupancy, as I said. So the question really comes down to, what did the legislature intend when it authorized the creation of these foundations to benefit the state universities? That's got to be the touchstone, of course, of all statutory interpretation. Sometimes that's easy because you look at the statute and say, well, it's clear and there are no adverse consequences. We can easily achieve this end. In this case, it's not so clear, because if you interpret it in the way the assessors say, you really destroy a large benefit of what the legislature wanted to do here, because suddenly this property, which in our hands and use is untaxable, and in the hands of the use of the university is untaxable, becomes taxable.
Following that, I take it you would say this is really, or you can almost think of this as sui generis, because of the specific statute setting up these charitable foundations to benefit the university, so that you're not creating some huge loophole for taxation.
That's exactly right. Yeah, this is a very unique situation because we're a tax-exempt body benefiting another tax-exempt body. It's not as if some taxable body could slip into this and say, oh, suddenly our property is not taxable either. No, you're right. Sui generis is exactly the right phrase for this. And the Appellate Tax Board got it exactly right. They talked about legislative intent, and they said in this particular narrow case, use equals occupancy. And we believe that is exactly right. We think that tax exemption plus tax exemption equals tax exemption, not taxability. And that the court should interpret this statute to achieve the legislative intent, which is to allow these foundations to accumulate money and assets to benefit the state universities, to relieve the taxpayer of another burden. And that can only be achieved, or best be achieved, I think, if we preserve the tax-exempt status of these.
But the appeals court relied upon its interpretation of Chapter 59, Section 5, third, and said occupied by it or its officers. Are you saying that under the plain language of that you would not be exempt, but because there is another statute which creates you, that should override this? Or are you saying that, or are you saying that it is occupied, that whatever occupied by it or its officers, you are doing that?
We say in this case that the Appellate Tax Board, which is entitled to some deference in this court, said that in this particular case, use equals occupancy, because we are dedicating this property to the exclusive use of our exclusive beneficiary. And the statute itself says that we exist exclusively for the benefit of this state institution. Use of the word exclusively would imply that we're free of an obligation to the city or town in which our beneficiary lies.
Does your foundation bylaws, or I should say articles of organization, are they dictated by statute?
They are. They parrot that language from the statute, saying that we operate exclusively for the benefit of Bridgewater State University. Those are reproduced in the record.
But when the statute says occupied by it or its officers, do you fit within the it?
It would be the entity, Bridgewater State University Foundation. We do, in a physical sense, occupy some of the property. We have our offices there in one of the buildings, and we use the so-called President's House for fundraising and other events along with the college. However, if you're going to go to a literal argument about physical occupation and control of other buildings, we don't. We simply don't. The university maintains the buildings. It uses the buildings for its own purposes. But what it requires here is to look at the intent of the legislature. The precedents of this court clearly say you look first at the legislation as it's written, but if that doesn't achieve the intent, then you perhaps will interpret it in a way that's not quite obvious in order to do what the legislature wants to achieve here. And what we want to achieve here is a benefit for the college. We don't maximize that benefit if we're paying taxes to the
But
town.
I guess what I'm asking is, the statute seems to distinguish between being occupied by the charitable organization and being occupied by the officers of the charitable organization. And I'm trying to figure out why they chose to distinguish them. It says it or its officers, so it imagines a use by a charitable organization that would not include occupancy by officers. Now, what do you understand that to include?
I do not understand what the phrase "its officers" means. I mean, obviously, its officers are not separate entities from the Chapter 180 corporation itself. I mean, the only thing I could hypothesize is that if a corporation, a Chapter 180 corporation, maintained offices in a commercial building, that perhaps a portion of that would become not taxable, but that's only a hypothesis. It's not presented here. Our officers, in fact, some are employees of the university, but most are independent. They meet as a board, and they administer the assets. But these assets in themselves are really used by the university because that is our purpose in life, to exclusively benefit.
Okay, so you're really saying, okay, we don't fit within the language of Chapter 59, Section 5, but to accomplish the purpose of the other legislation, we need to define this in this particular way, specific to the foundation and state university situation.
Yeah. You've got to harmonize the statutes that permitted us to be created and that created the university, and the statute that gave us and the university tax exemptions, and look at the purpose of it and say that in this particular case, use equals occupancy, because that is obviously what the legislature intended. And from reading the amicus briefs, you'll see that there's been a great deal of reliance upon this, because it's frankly the most intuitive and obvious approach you would take to the use of real estate like this by the beneficiary.
I understand your argument. I have a further question because I am not familiar with this statute, and I take it you might be. And that's at subparagraph E of Clause 3rd in this Chapter 59. And I know it says, and I know that we're not speaking here of charitable, of organized education institutions, organized as charities, but we're still, and the language of E, I was wondering whether you think there's an argument here that an educational institution, which this references, coming within a description of a charitable organization, which seems to me an odd way of referring to it rather than just saying a charitable organization organized for purposes of education, just coming within a description of a charitable organization. It says in that clause that that property assumes it's going to be exempt except as to only offices of residence for officers, which are not part of the contiguous real estate. So do you read this as inapplicable to the situation here because it really only means an educational institute that's been organized as a charitable organization? Or can you read that as saying an educational institute that's not for profit, like a public institution such as the one we have here, which otherwise, although not so organized, falls within the definition of a charitable organization?
Excuse me while I look at the statute
Yes.
here, because I have not thought about this. The charitable organization is defined early in Section 3rd here, as I recall,
Yes, benevolent,
So,
literary.
as a literary, benevolent, charitable, or scientific institution or temperance society incorporated in the Commonwealth. So does Part E fall within that? It might. What I can say, though, is that Bridgewater State University performs a classically charitable function by providing education. And it's a function, admittedly, which is taken over to a large extent by state entities, but we have many private entities as well.
Right.
But certainly from the very historic foundation of this Commonwealth, we saw education as a charitable function that the state is now performing. And frankly, I think it's very paradoxical that in this case, we lose the tax exemption because we're performing our charitable functions to help provide education, a classic charitable function.
I guess I thought, depending on how you define what the terms in subsection E, what they mean, it could reflect an intent of the legislature to include within its ambit educational entities that have a charitable purpose rather than a profit purpose.
I agree.
I'm not familiar with
I
its
agree.
use
Yeah.
anywhere, so,
Yeah.
okay.
I agree.
I just don't know.
In conclusion, I ask the court to harmonize these 4 statutes involved here and to uphold the Appellate Tax Board's opinion, which we believe was exactly right. Thank you very much.
sir.
May it please the court. My name is Mary Butler. I'm here on behalf of the Board of Assessors of the town of Bridgewater.
So what does it mean to occupy real estate held solely for the exclusive use of the university? How does one occupy real estate that one is supposed to be holding exclusively for the use of the university?
Case law supports, and citing specifically Charles Bank, that the property should be occupied by the foundation, charitable organization, or by its officers.
So, but so I'm asking, what does that mean in the circumstances presented here? Does it mean a phone booth on every corner of each parcel with a phone or a desk?
I think we would have to look at the 2-part test, which is occupancy and also in furtherance of its charitable purpose. Putting a phone booth with a desk on a property
Well,
is...
the officers could make phone calls from there
Actually,
on foundation business.
I don't know if that's exactly what at least Sturdy suggests, contrary to what I think the appeals court said, is that the foundation is entitled to a charitable exemption with respect to that portion of the property only if the corporation is also a charitable organization. So it itself, and occupies. So the occupation extends both to the foundation and the corporation in which for which the foundation was created, as long as the corporation, in this case a medical entity, was also charitable. Isn't that analogous to this situation? You don't have to just look at the foundation. You look to the entity for which it acts.
Correct, but in the Sturdy Memorial, the issue, and I do believe the issue was that the corporation did not fully satisfy the charitable purposes.
That was the issue. But the statement in discussing whether it might have been okay had they fulfilled the prerequisites of being a charitable organization, and they failed there.
Correct.
Had they, though, the premise would have been, and the case holds, yeah, you would have had the exemption.
Well, the statute, I feel, is very clear, and again, Charles Bank tells us that there is a simultaneous requirement that the property both be occupied and used to further the
Doesn't
charitable
it
purpose.
seem peculiar, though, in this case, I mean, in this, when you're applying it to this particular situation where you've got, if it was occupied by the foundation, it would be tax exempt. If it was occupied by, and owned and occupied by the university, it would be tax exempt. But when it's owned by the foundation and occupied by the university, which is the only entity for which the foundation exists, it's taxable?
It does seem a bit odd, Your Honor. However, I feel the statute, Section 5(3) of Chapter 59 is clear and unambiguous. The foundation argues that you need to look at the statute that authorized the creation of the foundation in light of
But
the
sometimes you
intent
look to
of
see
the-
whether the result of such an interpretation is ridiculous.
Yeah,
I mean,
absurd.
it almost falls into the absurd category
Well,
as applied to these circumstances.
the statute that authorizes the creation of the foundation does not require that the foundation hold property. It says that it's to be created for the specific use of and to the benefit of the college. It also says that in no uncertain terms is the foundation to be considered an arm of the Commonwealth. It specifically
Right.
says that.
These are for all kinds of tax reasons and for the whole purpose of encouraging donations that will benefit higher universities that won't get gobbled up by the state for other purposes, right? That's the whole purpose of the legislation.
But if we were to overturn the appeals court's decision, we would be rendering superfluous the language that's specifically stated in Chapter 59,
Well,
5
the specific language would also preclude the interpretation in Sturdy, right? Do you think this is wrong, that a foundation can't hold property that is occupied by a charitable entity that is not it, but for whom it acts? Forget this one. Just say another, a a private school organized as a charity, not-profit.
I think if another charitable organization was to occupy the property, it would need to be used in furtherance of that specific charitable organization. And
But you
that-
can't have that kind of a charity.
But that comes directly from the statute. That's the opportunity.
No, but I mean, you can't, the foundation cannot, it has to be used for the college purposes. They cannot, I take it, they can't even, under their articles of organization, they can't rent to another charity, can they?
I do not know, Your Honor, if that is prohibited. They certainly,
Could they build a dormitory? Could the foundation build a dormitory and charge students at the college tuition, or, room and board?
well,
Would that satisfy the requirements of the statute?
under the case law of Morse, I believe that they perhaps would be entitled to the exemption there because they are maintaining some control and possessory use of the property.
But they couldn't lease the land to the university and have the university or the college build a dormitory on the land because now the college is occupying the property.
Correct. The exclusive use precludes the owner charitable organization from receiving any sort of tax exemption. It is a bit of a enigma. But we do believe that the tax statute is to be strictly construed. It is basic first-year law school principle that you learn that tax statutes are to be strictly construed. When there's an ambiguity, they are to be resolved in favor of the taxpayer. But here, the language of the legislature is clear. I feel that the intent of the legislature is clear because
Why would the intent, what do you think the intention of the legislature is here? What is the intention?
with respect to charitable organizations receiving
With
tax
respect to
exemptions on
this
property.
particular,
How these two statutes
Yeah.
intersect?
Well, the legislature may need to speak to that, but I do not feel that it is for the court to decide.
We decide intent all the time. It's very difficult when you have statutes that, in working together, end up with results that clearly were not intended.
If the legislature intended for the foundation to receive some sort of tax exemption, then perhaps in the statute that allowed for the college to receive the tax exemption, it could have included some language that would allow the foundation to fall under that category. But it specifically excludes the foundation from being considered an arm of the Commonwealth.
Right. Now, so we know that the foundation does occupy some of this property. They have an office there.
I would argue, Your Honor, that
That they don't occupy the whole thing in some
There-
physical way?
there are 6 properties in question. 3 of them are unoccupied open parcels of land, and it is undisputed that those properties are used by college students.
So how does the foundation occupy open land?
It does not.
That's what I'm saying. How does it occupy open land? It can own open land. Can it be part of the real estate that it has in its portfolio?
It would be allowed a tax exemption for 2 years if it was going to remove itself to that property, but in this case, in the case before us, that is not the
Do we have any cases in which there are foundations established, conservation foundations established for the purpose of keeping open space, which purchase land to leave it open space, and are they taxed?
I have not found such case law. The foundation does cite certain Wheaton and Emerson with respect to these open parcels of land, but in those cases, the owner was determined to be the very entity, the college, that was looking for the exemption. There was no separate foundation holding the
But
property.
it sounds as if there were a conservation foundation for the purpose of preserving open space, say in Boston, which purchased a lot for the purpose of it being a park, that park would then be, the property would be taxable because it's not being occupied by the foundation?
I'm sorry, Your Honor, I cannot speak to that.
But that's the principle which you would be applying.
That under the charitable exemption in Chapter 59.5, the foundation would not be entitled to that tax exemption.
So when you say occupied by it, you mean it has to be physically be used by the foundation for the purpose of administering the foundation, as opposed to for the foundation's true purpose, which is either to preserve open space or to help build a university.
Yes, Your Honor.
I haven't had a chance to look at the amicus brief yet. Are other assessors in other towns where state colleges are and these foundations are they doing the same thing that you are, that West Bridgewater is? Do you know?
We do not know. I have read the amicus brief, and I do understand that, you know, one way or the other, someone's going to be unhappy about the decision, whether it's the foundations and the universities and the towns, or whether it's the towns not getting the tax revenue for themselves. It's, you know.
How long has Bridgewater taxed in these particular properties? I know the years that are involved here. Has that been going on for a long time?
As far as I know, I've only been there for a few years myself, but yes, I believe the foundation was established in the 80s, and the college has been there much
Presumably
longer
would have
than
been in the 90s,
The 90s.
I think, unless it was established under another statute. All right, so I guess the question is, we know that the tax was assessed and paid for fiscal 2007, and for the next year it was not paid, and those are the 2 years in question. So has this tax been assessed going back 10, 15 years, and this is the first time the issue's arisen?
I believe so, Your Honor. I do believe that the foundation has filed applications for abatement since this case has been before the courts.
But there was one, let's take the political science classrooms that were used in part of the buildings, and then the alumni office.
Yes.
That was used. Those were clearly for the purposes in which the foundation was set up,
Yes.
right?
The political science was used exclusively by the college. The alumni office was used by the college, but an office or an office space was reserved for the foundation.
So long as they had an office on the building, even though it was used, 90% of it was used by the university or by the college, the Board of Assessors recognized that and gave them a 100% charitable deduction or exemption?
I would argue that they would not be entitled to 100%. Analogous shared possession case law, such as Morse, has said that the owner does retain that right to exemption. However, you look to the case such as Babcock, where you know, the property was used for a few meetings by the Board of Trustees or Directors. They housed some furniture there on behalf of the charitable organization. The court found that that did not constitute occupancy for respect of the statute here at issue. So yes, they do have some presence there on those two properties of the 6 that are being assessed, but the occupancy, the extent of their occupation is not so great that it would qualify as.
So a hospital is set up to treat poor people. They've got this big building on a piece of land, and poor people come in, but it's occupied. The assessors would view the hospital as actually occupied by the charity, right? Not by the poor people.
In that case, absolutely, because
But in this case, if the building is set up by the foundation for the college sends its people in, just like poor people come into a hospital, but you don't recognize that kind of use.
I would point to in the record appendix is the agreement between the foundation and the college, and it speaks directly to the space and facilities that are to be used by the college and the foundation. And with respect to the foundation's offices, the college reserves the right to, or has the authority. It furnishes the property. It provides the computers, the telephones, the desks, the furniture for the benefit of the foundation, and it retains the authority to assign the location of the office for the wherever it may deem appropriate where the foundation offices should be located. So the foundation really does not retain any sort of ownership control over where it's located. It also, as my brother said, that the college does provide some personnel to work for the benefit of the foundation, so far as it even assigns its vice president of institutional advancement to act and discharge the duties of the executive director of the foundation. So the personnel of the college are in fact being used to satisfy some of the duties, and granted, The extent, I do not know, but that is just what is listed in the agreement. Finally, in that agreement, it also says that the foundation shall use the college's offices and/or its equipment subject to the rules, regulations, directives, and other requirements as the college may from time to time issue. So again, the college is maintaining control over the foundation's use and occupancy of the property. And with respect to the functions that are used at one of the Park Place properties, both the college and the foundation use that space for donor receptions, events, and functions. I would not say that an occasional donor reception would amount to the occupancy that is required under the statute. If the panel has no further questions, I'd like to ask that you please affirm the appeals court's decision. Thank you.
you.